Want to know the biggest mistake residential property managers make when it comes to tenancy disputes? They file in the wrong form. I was recently called by a client, principal of an office, who was in a bit of a panic because a landlord was really furious at his office. What had happened was the tenant had been late for a number of months in their rental. So the property manager had filed in VCAT, being it was a Victorian property. All the documents were correct, but at the very first hearing, the tenant pointed out that the landlord lived interstate. He wasn't a Victorian resident. So the VCAT member immediately ruled that VCAT does not have jurisdiction to hear this, and the whole matter had to be transferred to the magistrate's court. This is important because it caused more delays in the process, so the landlord was upset. And it's really important to note, and this is where sometimes property managers can go wrong, in that when it comes to, under the Residential Tenancies Act, VCAT only has jurisdiction to hear those matters if the landlord resides in Victoria. If the landlord lives interstate or overseas, VCAT does not have jurisdiction, and you need to take the matter up in the magistrate's court. Court is not like VCAT. The rules are slightly different, so feel free to reach out if you need help, because we've got a legal team that can assist in these matters and do. But it's as important to remember that if your landlord is overseas or interstate, don't go to VCAT for assistance, because if the tenant points out that they're overseas or interstate, VCAT does not have jurisdiction.